I would like to thank the Sydney Indigenous Artists Centre for inviting me to speak to members today about protection of their Indigenous art. Today we'll be covering the legal framework of protection in Australia and current issues, and I'll provide some practical tips on how to better protect your creations. As an Indigenous artist, it is important to protect your art, which can be in many forms. Art can be writing, music, performances, artistic work, intangible cultural property, and documentation of Indigenous people's heritage in all forms of media. There are various ways that art can be protected, and today we're going to talk about these areas, which are copyright, design law, and patents. Copyright is an asset of creators that gives them legal rights and opportunities to generate income, irrespective of the ownership of their physical creation and irrespective of whether that creation still exists. Copyright owners have the exclusive right to reproduce or copy their work, the right to communicate their work to the public, including making it available online or broadcasting it, the right to first publish their work, the right to perform their work in public, and the right to adapt their work. As a copyright owner, you also have the right to stop someone from using your work. Copyright protection is automatic upon creation. There's no need to register it. I'm sure everyone knows the symbol which identifies copyright. It is not, however, necessary to always record this symbol in order for protection to exist. In order to gain copyright, the artistic work or other subject matter must be expressed in a material form. You cannot protect merely an idea or theory, so a creator cannot rely on copyright law if someone stole his or her idea if they hadn't put it down in material form. Artistic works also must be original, but subject matters other than artistic works need not be original. A tip to ensure that you are entitled to protection is to ensure that you always put your ideas down in a form of data. So who owns the copyright? Well, there's a few rules for each type of work, and I'll just briefly cover off on what they usually are. Generally, the author of a literary, dramatic, musical, or artistic work owns copyright in the work, and generally the maker of a film, a sound recording, or a television or sound broadcast owns the copyright. In the case of a film, that's usually the producer. In the case of a sound recording, it is generally the record company, or in the case of a live performance, the person who made arrangements for the performance, which is usually the performer. In the case of a broadcast, it's the broadcasting company who is the owner. There are exceptions, however, to these rules. In the case of employment, if the work was created in the pursuance of their employment, then the employer owns the rights, except in the case of journalists for photocopying or publication rights, and then the employer owns everything else. In terms of contract, it's where the author has contracted away their copyright rights to another. In the case of Crown rights, the government would own the rights, and that's because it's been under the direction of the government. And in terms of commission works, it's usually the person who commissioned them, and that's because they've paid for that service. Copyright generally lasts for 70 years after the death of the author of the work. In the case of subject matters other than works, copyright lasts for 70 years from the year of first publication of a sound recording or film, 50 years from the year a television or sound broadcast was made, and 25 years from the year of the first publication of a published edition of a work. Copyright lapses after the relevant time period, and the work is then in the public domain. This means that anyone can use it. What should you do if your copyright is infringed? Firstly, you should write to the infringer, issuing a letter of demand. If this fails, you can take the matter to court, and if the court agrees that your copyright has been infringed, then you can seek such things as injunctions, damages, or accounts of profits. In the case of internet infringement, you can also issue a takedown notice. Takedown notices are provided in the regulations, and they are sent to infringers publishing online material. On receiving the notice, the internet service provider must promptly remove or disable access to the copyright material. Additionally, you can also license use and agree on how the material can be used between you and the infringer. Dealing with copyright. There are two main ways of dealing with copyright: assigning or licensing. By assigning, you are transferring your copyright to a third party, which then owns it with all the rights deriving from copyright ownership. A tip that this must be in writing and signed by the person transferring the copyright. By licensing your copyright, you allow someone else to exercise some or all of the exclusive rights of a copyright owner. If you license your copyright material, it is important to determine the permitted uses, the territory where the license is valid, for how long the license is valid, any sub-licensing rights. This is where the licensee may have the right to allow others to use material in the manner contemplated by the license, the nature of the license, and any payment by the licensee. Payments can be in the form of a periodic fee on a royalty basis, a flat fee, or a combination of those. There's also the existence of things called implied licenses. This is where, for example, you might pay for an illustration to use in a book, and therefore you have license to use it in that book as you have paid for that service. A tip here: although exclusive licenses are the only ones that need to be in writing, it is best to have the license terms in writing, as there is evidence of what the terms of the lease are in the event that a dispute arises. Creative Commons is a fast-growing organisation which provides free, easy-to-use copyright licenses to make a simple and standardised way for the public to have permission to share and use your creative work without payment. The organisation runs on the ethos that the internet is a multiplier of cultural innovation. Creative Commons licenses make it easier for individual creators of culture to express themselves and to identify the freedoms they want their creativity to carry on the internet. There are 4 variations of the license that they offer, and this can be valuable to those artists who wish to control the sharing of their work. Artists have moral rights. Moral rights protect the personal relationship between a creator and their work, even if the creator no longer owns the work or the copyright in the work. They concern the creator's right to be properly attributed or credited and the protection of their work from derogatory treatment. Unlike economic rights, moral rights cannot be bought or sold or given away. However, after the creator passes away, the moral rights can be exercised by the personal representative of the creator, for example, the executor or administrator of the creator's estate. If moral rights have been infringed, the court can order various remedies, for example, a public apology, a correction, a declaration of infringement, damages, or an injunction. We will now look at protecting designs. Design protection gives the design owner a monopoly in the visual features of shape, configuration, pattern, and ornamentation of the design. Designs can be protected under 2 regimes: the copyright regime or the design regime. Artists wishing to embody their artistic work in a design to produce a product range should be cautious about relying solely on copyright, as copyright protection may be lost when the products are offered for sale. A creator wishing to protect a design needs to decide which regime is most suitable, based on the intended use of the design. Copyright protection or design protection, or both, may be lost in a number of ways. Unless dual protection is possible, the creator loses copyright protection but gains design protection once a design is registered. The creator relying on copyright protection solely might lose that protection and be precluded from design registration when the design is applied industrially and the resulting products are sold or let for hire or offered for sale or hire. A design must be new and distinctive in order to be registered under the Designs Act. In order to be new, it must not be identical to a product design publicly used in Australia or published in a document anywhere before the application to register the particular design was filed, or a design disclosed in an earlier registered design application. For a design to be distinctive, it must not be substantially similar in overall impression to a product designed publicly used in Australia or published in a document anywhere before the application to register the particular design was filed, or a design disclosed in an earlier registered design application. The registered owner of a design has exclusive rights in respect to that design, including the right to make a product that embodies the design, import, sell, hire, or dispose of a product that embodies the design, and authorize others to do any of those things. A registered design is infringed if, without license or authority of its owner, a person makes, sells, hires, or imports a product, or uses for trade or business a product embodying a design that is identical or substantially similar in overall impression to the registered design, or authorizes a third party to do any of those acts. The registered owner of a design can only act against an infringer once a certificate of examination has been issued by the registrar. Patents are a way of protecting inventions. If you have created a useful product or process, you may be entitled to register a patent. Medicines, treatments, and other products which are novel and inventive can be protected. However, a patent is unlikely to be available to protect traditional medicines or treatments based on traditional knowledge handed down over many generations. It is important to note that applying for a patent can be a complicated process, and IP Australia advises seeking the professional assistance of a patent attorney when applying for a patent. Many patent applications filed without professional assistance fail due to lack of knowledge or experience with the law, technology, or the procedural requirements associated with lodging an application. Amendments are needed to existing laws to adequately protect and recognise Indigenous arts and cultures. Whereas Indigenous people may have access to intellectual property laws, they are often not adequately informed and lack resources to bring costly and time-consuming legal action to enforce these rights. More support is needed by way of reform to address the vulnerability of Indigenous artists. Intellectual property rights are inadequate because they are based on Western notions of property that emphasise individual ownership. It does not recognise the Indigenous notion of communal rights or acknowledge cultural differences in ownership rights. Because of this lack of recognition of Indigenous ownership rights, there's a lot of Indigenous art or subject matter that has been stolen, as historically there's not been an appropriate mechanism to attribute the knowledge to an owner. Some other countries have developed ways to address this through databases to make knowledge part of the prior art base. Also, it should be noted that copyright laws do not recognise continuing rights of traditional custodians to limit the sharing of secret or sacred images of Indigenous knowledge once the term of copyright has expired. Once it expires, Indigenous owners lose ownership rights and it is in the public domain. Reform is also needed in the current patent system. The current patent system is grossly inadequate in protecting Indigenous artists and their inventions. Much Indigenous knowledge concerning agricultural, pharmaceutical, and scientific practices passed down through generations is not generally patentable because it cannot meet the requirements to be covered by the law. Additionally, upon expiration of the patent, the invention becomes freely available to use. Indigenous people, however, seek to hold rights in medicinal and plant knowledge in perpetuity. This makes patent registration unsuitable as a method of enforcing rights in Indigenous knowledge. Indigenous people have also been prevented from being able to patent their traditional medicinal remedies because much of this knowledge has been published by researchers or by Indigenous people themselves and has therefore become part of the prior art base and no longer patentable. Therefore, in order for Indigenous art to be properly protected, there needs to be significant reform in the IP area to address these inadequacies. These are the sources for the information that I've used in the presentation. Thank you for listening to my presentation today.